Hello, everyone. Thank you for joining me for today's topic, which is Protect Your Wealth, Estate Planning Secrets to Protect Your Assets. I'm thrilled that you're joining me today. My name is Lynn, St. Louis, and I'm an estate planning and elder law attorney at ELG Estate Planning, where we serve clients in Washington and in North Idaho. ELG's mission is all about empowering futures. Through our estate planning and elder law services, we help clients empower their life goals. And I'm very excited that you are joining me today because we are going to be talking about some really important issues today, which is estate planning secrets to protect your assets. I need to start out saying we are not financial advisors. We are attorneys. And if you are concerned about your assets because perhaps your portfolio has gone down, perhaps you've heard about bank failures, there's things going on in the world that understandably you may be concerned about your assets. We're not giving any investment advice. I hope that you have a great financial advisor to give you that guidance. We're not going to be talking about that today. We're going to be talking about estate planning techniques and secrets. Now, because this is a general educational type discussion, I am not giving any specific legal advice to anybody who's joining us here today. I'm going to be going over fundamental estate planning techniques and methods and secrets to put into place a good estate plan that works for you to protect your assets, because that is really important. And there are so many things that you can do. I will try to cover as many as I can today. Please put your questions in the chat if you're joining me live via Zoom right now. And I will answer all of those questions before we're done today, or at least I will try. And I am so glad that you are joining me. And your reason for joining me may be you just want to learn more, or it could be you just had your estate plan, or you're thinking about having your estate plan done. There's a lot of reasons people want to get more information about estate planning. Perhaps something has happened in their life. Maybe there's been a bad diagnosis, or somebody that they know and love is ill, or somebody has passed. I mean, life happens, and estate planning is all about making sure that you have the protections in place to cover whatever situation could arise. And that's one of the goals that we have as estate planning and elder law attorneys, is to give you the legal protections that exist so that you have the best plan possible. Sometimes people have no estate plan, or they think they have no estate plan. And a little known secret is, whatever you've done or haven't done, you have an estate plan. That seems confusing. Let me explain. If you've gone to an estate planning lawyer, an elder law attorney, and they've done an estate plan for you, fantastic. If you have done your own estate plan online, understandable. You're trying to save money. You're not giving guidance. I don't know what your estate plan looks like, but I think it could be improved on by getting legal counsel. But let's say you're one of those people that have done nothing. You have no estate plan, or at least you think you have none. You actually do have an estate plan. What estate plan is that, you might say? It is the state's estate plan. So by default, the state that you live in has an estate plan for you. Now, it's not going to be a good one. I can bet you that. It'll involve the state becoming involved if you become disabled, a guardianship, your assets going where the state says they should go upon your death, and not easily, and with quite a bit of cost. So one of the things that I want to clear up is you may think that by doing nothing, you have no estate plan. That would be mistaken. You have an estate plan. It's just probably not the right one for you because it's what the state's default plan is. All right, so we have a lot to talk about. Let's go ahead and get started with estate planning secrets, how to protect your assets. Let's talk about how to protect your assets during your lifetime first, and then we'll talk about how to protect your assets after your passing. I am sure that virtually everyone listening has heard the term trust. And that's what we're going to be talking about, because there are trust techniques, various types of trusts that are very effective ways to protect your assets. Now, whenever you hear the term trust, that actually should just kind of make you think, well, what kind of trust are we talking about? And maybe that's only as an estate planning and elder law attorney I will think that, but there are so many different types of trusts. So if you hear somebody say, oh, you can use a trust, the next step or the next question should be, well, tell me more. What kind of trust are you talking about? Because trusts have many different forms and many different protections or not, depending on the type of trust it is. So let's get started with what we first call lifetime trusts. In the legal world, they're also called inter vivos trusts. All that means is a trust you create during your lifetime. Now, within that category of lifetime trusts, you have irrevocable trusts and you have revocable trusts. We're going to start with the irrevocable trusts, and I'm going to describe what that is. An irrevocable trust is a trust that you create during your lifetime. And because it's irrevocable, this is something you are definitely going to want to work with an attorney on, because when anything is irrevocable, it's not supposed to be changeable. And you want to make sure you get it right the first time. So most trusts that are lifetime trusts are called revocable for good reason, but we're first focusing in on irrevocable trusts. And the reason for that is irrevocable trusts give you a great deal of asset protection. So an irrevocable trust is one that you create. You're the grantor, you're the one that creates it. You can even be the beneficiary of that trust and the trustee of that trust. Why are you creating this trust? Well, there's many reasons. One I mentioned is for asset protection. You take your assets and you put them into this trust. So because it's an irrevocable trust, you no longer own those assets at all, though you can be a beneficiary of those assets for most purposes. So think about when you do, it's tax season right now, when you do your tax returns, you use your social security number and you report on your assets and your income, etc. With an irrevocable trust, it does its own tax return. It has its own tax ID number because it is its own legal entity. If you give your assets to an irrevocable trust, you no longer own those assets. They are owned by the trust. Why would you do that? Well, there's some really good reasons why you would take your assets and you would put them into a trust, an irrevocable trust. Let's say you want to make sure that those assets are not subject to any creditors that you may have. You can put those assets into the trust. Now, don't get me wrong. If you already have those creditors coming after you and coming after those assets, you can't then say, oh, I'm going to get rid of them. I'm going to put them in the trust. That's defraud of creditors. That's not going to work. I'm talking about the situation where you are concerned about future creditors and that you don't want them to have any access to your assets. So you put them in a trust. This is one of the best ways that you can make sure your wealth is protected from creditors. So creditors are a very big reason why people put money and assets into an irrevocable trust, because it does protect them, those assets. Another big reason people put money into an irrevocable trust is they want to get it out of their estate. By that I mean out of their what the federal government would consider, or the state would consider, the person's estate. And when I'm talking about estate, why I'm saying that is like upon death, you're probably familiar that there is an estate tax. If you take those assets and get them out of your own ownership and put them into an irrevocable trust, they are outside of your estate and you're not going to be taxed on those when you pass. So minimizing estate taxes is a purpose that is well served by use of an irrevocable trust. And I don't want to get in, well, let me talk a little bit about the estate tax laws. Right now in Washington State, we have a $2.193 million credit exclusion amount. The majority of states don't even have an estate tax, but we in Washington do. At the federal level, currently in 2023, it is $12,920,000 is the federal tax exclusion amount. So if you are in a state that has no estate tax, Idaho, for example, you can pass $12.92 million and none of that is subject to an estate tax. Nonetheless, people want to put certain assets into an irrevocable trust because they are concerned that they are going to have a taxable estate. So what kind of assets would somebody put into an irrevocable trust if they think, oh boy, I'm going to have, a $20 million estate or a $30 million estate? Think about startup companies. Think about stocks that you think are going to go meteoric, for example. If you take those stocks and you put them into this irrevocable trust before they get all of that gain, well, then all of that growth in that asset is occurring not in your estate, but in this trust. And trust can be set up to go on and on and on. Dynasty trust, you might hear them called, legacy trust. They can be, you could set them up for the benefit of your children, your grandchildren, and it can go on for a number of years until at some point in time, the law says they can't go on any further. In Washington State, that's 151 years. So it seems like a long time. So one of the reasons to have an irrevocable trust is to minimize estate taxes. It also, and so what we're talking about right now are people that have significant assets, for example. You can put your assets into this trust, they are protected, they can grow, and then you can keep putting certain level of assets into it. In Washington, for example, we don't have a gift tax, so you can gift $12.92 million and pay no gift tax, and the federal government is fine with that as well because it's within the exclusion amount. You don't pay a gift tax. You're the recipient, either the trust or any person you might give it to, they don't pay any kind of a gift tax. So it's a good way to reduce your estate is by actually giving it away, and that is going to protect against the imposition of estate taxes. When you give assets to people, either during your lifetime or upon your death, then the federal government and the state is looking at it and saying, do we need to impose an estate tax? I do want to point out that charitable giving is a way to take your assets and give them to a cause that is near and dear to your heart, and there's no estate tax imposed when you give to charity. When you use something that's called a charitable remainder trust, you get to retain the income, but the asset goes out of your estate. So as you can tell, a lot of what I'm talking about right now with irrevocable trusts are people who are concerned, yes, perhaps about creditors, but primarily they're concerned about protecting their wealth from estate taxes, and that occurs upon death. So even though you create it during your lifetime, it's a lifetime trust. It has an effect during your lifetime and upon your death. A lot of people are confused about what I probably just said about this gifting. Who here remembers that you can give away $10,000 a year? I'm sure a lot of us do. Well, guess what? In 2023, that amount now is $17,000 a year. And so if you are married, you can give away $34,000, and not just to one person, to an unlimited number of people. And you don't even need to mention to the IRS that you gave away, for example, you and your spouse gave away $340,000 to 10 family members, because it's within the annual exclusion amount allowed by gifting. Giving away assets is something that can be done to avoid estate taxes by bringing down your asset level. I was talking about the irrevocable trusts. You can also do that annual exclusion gifting to an irrevocable trust and add more money to that trust every year. If you don't want to give it outright to family members, you can give it to the trust that you set up for the family. So that's a great way to protect against estate taxes, protect your beneficiaries against misuse of the trust money, against creditors. You can set up your irrevocable trust to be what's called intentionally defective, which is kind of an odd term, I think, but what it means is that if you set up your trust in a certain way, even though you've given it all away and you have set it up so that you still have to pay the income tax on it. Now, why would you do that? Well, to reduce your assets. So it's kind of an ironic thing here. We're talking about protecting assets. One of the ways to protect assets is put them into a trust, reduce your own assets, and avoid estate taxes on your death. Another method to deal with an inevitable tax burden, for example, for people that have millions and millions of dollars, is something that's called an ILIT. It's an irrevocable life insurance trust. You buy a life insurance policy, which is put into this trust. It is considered to be outside of your estate, and it is purchased with the idea that upon your death, the proceeds of that will pay any estate tax imposed. So the tax code is driving all of this, everything that I am talking about. All of these different mechanisms for taking assets out of your estate and reducing your estate and avoiding estate tax all has to do with the tax code. Paying to charities, which is not taxed, all has to do with the tax code. Tax laws change a lot, and they have changed so much over the years. I don't know, maybe you recall back not too long ago that there was one year where there was no estate tax federally, and there were some billionaires who died and they didn't pay any estate tax. Very timely. Right now, our next big tax change is set to come up in 2026. Exactly what will happen then? Who knows? It is going to be up to Congress to say, are they going to continue along the lines of our current type of tax structure, increasing the 12.92 million year after year, or are they going to cut it back to half, which is what currently is about what's slated to happen, which whether that will happen, I have no clue. I do not have a crystal ball, but I do know that if you have an estate that is worth multi-millions of dollars, you should be talking with a tax attorney about how to protect yourself against these future tax changes that we're looking toward in 2026. If you live in Washington State, which is a great state to live in from an income tax perspective, because we don't have income tax aside from this new 7% capital gains tax that just was approved by our Supreme Court this past week. It's a great state for income tax for high earners, but it's not a great state to die in. So people may consider going to a state that doesn't have high income tax or estate tax, which for Texas, for example. So when you're looking at how to set up your estate plan and you've got a lot of money, sometimes you're looking at what's the best jurisdiction for you to live in. Other ways to protect your assets. Let's say you're not in this multi-million-dollar state that I'm talking about where you should be seeing a tax attorney. Let's say you're doing okay, but maybe you have a few rental properties and you've got maybe 2 to 3 million, but you're not worried about paying a federal estate tax. I would recommend that you consider putting your rental properties into what's called a limited liability company. What that is this protective entity in which you put like a rental property. Why would you do that? Well, when you have a rental property, you might be concerned that whomever you're renting to could get hurt, or somebody who's visiting them could get hurt. There could be a fire, there could be a serious injury, there could be a death. If you own that property in your own name, you yourself are subject to lawsuit, as well as all of your assets. However, if you don't own that property, instead your LLC owns that property, then that lawsuit can only go against the assets that are in the LLC. So you protected yourself, your other assets. The only asset subject to suit and recovery is that rental property that is in the LLC. And sometimes people don't want to put, like, maybe they have several rental properties and it's kind of a hassle every year to renew and do what you have to do with an LLC. So they put them all into one LLC. Keep in mind that if you do that, then all the assets within that LLC are subject to recovery for any kind of lawsuit. If you want to be very cautious, you would put each property in its own LLC. Of course, one of the fundamental ways to protect yourself against any kind of lawsuits is have adequate liability insurance. I used to do litigation. I used to do insurance defense. It is critically important that you have adequate insurance to protect yourself and protect your assets. And if you don't already have what's called an excess or an umbrella policy, please get one. It covers you for your driving, it covers you for your house, and if you do have rental properties, get one to cover the rental properties. Typically, they're at a level of $1 to $2 million. They don't cost very much, that being, perhaps $500, $600, $700 a year. And if you do cause an accident or you're sued, then it's much more likely that the plaintiff who is suing you will get a settlement which is acceptable to them, and none of your assets will be exposed because you have adequate liability insurance. So it's part of estate planning in a way, in that we often talk to clients about make sure you have good liability insurance. Really an important thing to do to protect your assets without having to use a trust. So we've talked about irrevocable trusts. We've talked about LLCs. We've talked about insurance. Talked a little bit about charitable remainder trusts and giving to charity to avoid your estate taxes. These are all things that are very good ways to protect your assets and your wealth. Now let's switch to talking about what we call a lifetime trust or an inter vivos trust that is a revocable living trust. Does a revocable living trust give you any of those protections we just talked about? No, none. A revocable living trust, let me talk about the fact that I am focusing in on Washington. Perhaps there's another jurisdiction, another favorable jurisdiction where a revocable living trust in that state will protect assets, will protect against creditors, will do something that's beneficial to protect your wealth. In Washington, that's simply not the case. A revocable living trust is not a way to protect your assets. And if anybody tells you you need a revocable living trust to protect your assets against all of these myriad things we talked about, you might want to get a second opinion. Revocable living trusts, you do create them during your lifetime. They don't have their own tax ID number. They use your social security number. They don't protect assets against creditors. They don't minimize your taxes. They are intended for two primary purposes, that being managing your assets in the trust should you become incapacitated, because there'll be a successor trustee that you've named. And number two, avoiding probate upon your death, which could be a very valid reason to have a revocable living trust, depending on your situation. But revocable living trusts are not giving you any creditor protections, at least not in the state of Washington. I do want you to be well aware of that. All right. What threats do people are they concerned about when it comes to their finances? We talked about creditors, talked a bit about lawsuits, we talked about estate taxes. As an elder law attorney, I can tell you that when we meet with our clients, one of their biggest concerns is long-term care costs, and rightly so. Long-term care expenses are one of the biggest threats to anyone's financial security. And of course, as people become seniors, as we age, long-term care becomes more of a probability than a possibility. So if you're thinking about that, you are right to be thinking about it and to be asking, what can I do to protect my assets against long-term care costs? Again, as I mentioned, revocable living trust won't do you any good. Can you use an irrevocable trust that you create during your lifetime to protect your assets from long-term care costs? And the answer is yes, you can. Again, because it's an irrevocable trust, you want to talk with your estate planning and elder law attorney. When do we recommend irrevocable trusts when people are concerned about long-term care costs? If you are a single person and you are very concerned that you want to make sure that your only child or your children get some of your estate and that it doesn't all get spent down on your long-term care that might be coming, then you create an irrevocable trust. Basically, you give away all your assets and you give them to them, and you gave it to them in a trust so that they are protected against their creditors as well. Medicaid has what's called a 5-year look back. If you create this trust 5 years before you ever need long-term care or you ever apply for Medicaid, it works. It gets the asset out of your estate, not just for tax purposes, which we're not concerned about at this point, but for Medicaid eligibility purposes. Creating a Medicaid 5-year look back trust can be an excellent planning option. But you want to make sure that you understand what's involved and you work with an attorney. What if you are that single person and you want to keep living in your house? You gave away that house to this trust. And if you want to make this work for Medicaid, you actually have to pay rent to your trustee. And then that trustee, that trust they don't give you any money from the trust. What happens if you need long-term care 3 years out? Well, there's a problem. We got to figure out a solution to it. We don't lightly create Medicaid 5-year look-back trusts. We only do it when it's the proper situation. I can tell you, in our practice, it's the minority of time that we do that because there's often better Medicaid strategies that are available. But having said that, it still can be an excellent planning option. We've created Medicaid 5-year look-back trusts for couples. We're less likely to do that because with couples, Medicaid's laws are much more generous than they are for singles. So if you're a couple and you're looking at Medicaid eligibility, you're both alive, Medicaid lets you keep about $65,000 to $135,000, $140,000. Let's say you have too much, you have more than that. Your house doesn't count, your car doesn't count, $135,000 doesn't count, but let's say you've got $100,000 or $200,000 or $300,000 beyond that, which counts. Medicaid allows you to buy what's called a Medicaid compliant annuity. You take, therefore, countable assets, i.e. money, and you make it non-countable by buying an annuity that Medicaid allows. This is done at the time of need, at the time of the Medicaid application. You never buy a Medicaid annuity before you need it. Part of the rules about Medicaid annuities is that the state has to be named the beneficiary of the annuity after the well spouse. So you buy it in the name of the spouse who doesn't need care. That annuity pays back to the spouse during that person's lifetime. Should they die before the end of typically a 5-year term, then the state of Washington gets the next payments. This is not your normal annuity. This is not the type of annuity your financial advisor would talk with you about. Most financial advisors would never sell this annuity unless they're working with an elder law attorney. The point of it is, however, that for couples, the rules about Medicaid eligibility are much more generous than they are for a single person. We have more tools. So we have a way to qualify couples, qualify the ill spouse for Medicaid without spending down their assets, without having to give them away by using, for example, the Medicaid compliant annuity. That's not to say that we haven't created Medicaid 5-year look-back trusts for couples. Absolutely, we have done that. Remember, Medicaid has a 5-year look-back. So if the couple is concerned that they want to protect assets, for example, for their family, there's a couple ways they can do that. They can actually just give the assets to their family. If the couple, for example, has that lake cabin they always want to keep in the family, they can give that lake cabin to their children, create an LLC for it, or an irrevocable trust. Any of those mechanisms work for getting that asset out of the ownership of the couple and giving it to somebody else. And if you do it 5 years before the need for Medicaid, before long-term care, Medicaid doesn't care because they only have a 5-year look back. They don't care what you did in the 61st month, for example. Sometimes we've given away, maybe it was a family farm. We gave the family farm and it was in an LLC. We put it in an irrevocable trust for the benefit of the children of the family. You can do all of those things to protect those assets, especially important with legacy property or with farms, etc. That is something that can be done. If it's done 5 years before the need, Medicaid eligibility is not impacted. So 5 years before the need is when you would give this sort of assets away to outright, an LLC, in a trust, irrevocable trust, etc. What I want you to know, and this is not commonly known, especially by estate planning lawyers that don't do, or elder law attorneys that don't do Medicaid applications, is that there are ways to protect your assets, not just giving them away 5 years before the need, but at the time of need. And the primary way to do that, at least for a couple, is through using a Medicaid compliant annuity. I really have to emphasize that because this is not well known. frankly, it is pretty much a secret unless you're talking to an elder law attorney that does Medicaid applications. So don't think you have to spend all your assets. Don't listen to the neighbor or somebody who said, no, you have to give everything away. Instead, seek out an experienced elder law attorney to help you, because you can protect your assets. We've been talking a lot about what you can do during your lifetime to protect assets. And we're talking about protecting assets for yourself and for your family primarily. There's also excellent estate planning tools to protect assets after you have passed away. If you want to protect assets for your loved ones, maybe your children will inherit from you, maybe your spouse will inherit from you, the best way to do that is through use of trusts. Now, revocable living trusts can be used very effectively to protect assets for your children, for example. Maybe you are concerned that if your child inherits from you, now they own this money and now they get a divorce. And now all your money went to the divorcing spouse. That's a pretty common concern. Through use of trust, you can create a trust in your own revocable living trust, which becomes irrevocable on your death, or through your will, you can create a trust for your beneficiaries to protect them against threats. Threats being divorcing spouses, their own creditors, their bad lifestyle choices, as long as they're not their own trustee, that is. So anything you can imagine, anything that causes you concern about, if my child were to inherit from me, I'm worried that they're not going to make good use of that money or they're going to lose the money, etc. You can protect against that by making sure that whether you're using a revocable living trust or whether you're using a will, that you create a trust for that beneficiary. What if you have somebody who's going to be inheriting from you that's going to need government benefits? Maybe it's a special needs child. Same sort of situation. You want to create a trust for that special needs person. And again, it can be created through a revocable living trust or through a will. If you do this properly, the standard for the trustee to distribute money to that beneficiary is what we call a discretionary standard. Really, really important that this type of trust be a discretionary trust, as opposed to what's called a support trust. Sometimes in trust, you'll see health, education, maintenance, support. That's a support trust. If it's a special needs person or somebody who's on government benefits, it needs to be a discretionary trust. Why is that? Because then the government will look at that trust and they'll say, oh, it's a discretionary trust. The beneficiary cannot compel a distribution. And if they cannot compel a distribution, the government doesn't count that trust as belonging to the beneficiary. Therefore, have a discretionary trust if you want very strong protections to your beneficiary and the opportunity to allow them to keep getting their government benefits or to qualify for government benefits. And it also protects against creditors because a discretionary trust, creditors can't reach any of the assets in that trust. Now, I've been talking about how you can protect your beneficiaries when you're gone, and you can do it through your own revocable living trust or your will, your last will and testament. There's one big exception here that is really important that we get that information out, at least in the state of Washington, is if you want to protect assets for your spouse when you are gone, and this is against long-term care costs so that they qualify for any government benefits to pay for their future long-term care, you must do so through your will. You cannot use a revocable living trust to protect assets for your surviving spouse when you're gone, because Medicaid won't honor any kind of trust that your revocable living trust created for your spouse. It feels like form over substance here, and perhaps it is, but it is very clear. Let's say that you and your spouse want to make sure you provide for each other, and like the majority of people who are older, you're concerned about long-term care costs. If that is your concern, that you want to make sure you provide for your spouse and that they would never become impoverished because they'll never have to spend down all of their money on long-term care costs, you have to use a will. You cannot use a revocable living trust. The will has within it a special kind of trust. It's that discretionary trust I was talking about. It's an asset protection trust. It's sometimes called a supplemental needs trust. And how it works is that both spouses have a will, and in the will has this trust. When the first spouse dies, their share of the couple's estate then funds this supplemental needs trust for the surviving spouse. All the assets in that trust do not count if that surviving spouse ever wants to apply for Medicaid. So let me give you an example. Let's say the couple has $1 million. First spouse dies. $500,000, the first spouse's share of this estate, we're in Washington, community property, is going to go into the trust for the surviving spouse. When that surviving spouse needs care and they apply for Medicaid, Medicaid won't count that $500,000 that's in that supplemental needs trust. What that means is that the state, when the surviving spouse is at the standard to qualify for eligibility, which is frankly only $2,000, when they are at that level, they can have the state pay for their care. The state allows $500,000 to be in this trust, and it doesn't interfere with eligibility. That money is there to support the surviving spouse in whatever care they need, but the cost of care will be paid for by the state, and the state will not have any rights to recovery from any of that money that's in the trust. And what that means is that money will go wherever the couple wanted it to go when that second spouse dies, and it will not go to the state. One of the most important tools we have to protect assets for couples against long-term care costs in the state of Washington is the will with the supplemental needs trust in it. All right, so I talked about protecting half the assets. In the state of Washington, you're also allowed to take what is called community property, and one spouse can give all of their assets to the other spouse through a separate property agreement. And what that does is that allows the couple to protect more assets for the surviving spouse. That is a more complicated concept, but I want you to be aware of it and speak with your estate planning and elder law attorney about it, that we can protect more than half the assets in the right situation. If we know one of the spouses is going to be passing, we can put all of the assets that can be put in their name and protect that for the surviving spouse through the will that creates the supplemental needs trust. One of the reasons you may have heard that revocable living trusts are better and should be used. Well, one of those reasons maybe is that you are in a different state. You're in California, for example. That in Washington, that's not the case, because in Washington, as I just explained, you need a will, not a revocable living trust to protect assets for your surviving spouse for long-term care purposes. Why do people have revocable living trusts, and why do they have irrevocable trusts as well? Is they want to avoid probate, because probate is something that people are very scared of because they've heard horror stories about probates. I can tell you that with a good estate plan, there will not be a horror story about your probate. There will be legal fees, and that's one of the reasons people want to avoid a probate. Rather than saying, I should avoid probate, the question that should be asked is, should I avoid probate? Is there a benefit to probate? What is that benefit? So if there's no benefit to probate, if there's no reason to have your estate go through probate, then set up your estate plan to avoid it. It can be easily done either through a revocable living trust, an irrevocable living trust, which is much more complicated to set up and administer, or even pay on death on bank accounts, transfer on death deeds on real property, etc. Probate can be avoided without much complexity, assuming that it's a fairly simple estate. Estates that are more complicated or taxable estates, it's a whole different ballgame. Avoid probate if there's no benefit. But if there is a benefit, if you want to protect assets for your surviving spouse against long-term care costs, then have a will. A will doesn't have any effect until there's a death, and on the death, the will is filed with the court and the probate process commences. An executor is appointed to administer your will, to gather the assets, to pay creditors that have to be paid, and then to fund the trust for the surviving spouse. In the example I gave you, coupled with the $1 million estate through probate, through the will, supplemental needs trust, and probate, we can protect $500,000 from all threats, from long-term care costs. A $500,000 benefit is certainly worth the cost of going through a probate. What I want you to keep in mind is that whether probate is right for you or not is really a question that you need to sit down and talk to your estate planning and elder law attorney about. When you hear somebody say you must avoid probate and they don't know the facts of your case, they're not giving you very good legal advice. So answering a question that was posted by someone in the chat, what assets are included in Washington estate tax? All the assets that are in your estate. So IRAs, anything that you're passing is included within your estate. Life insurance is included in your estate unless you took and you put your life insurance policy into an irrevocable trust. So remember, whatever you own is in your estate unless you put it into an irrevocable trust. Next question. I have a revocable living trust in Tennessee, but no longer live there. So your trust created in another state should be honored in the state that you moved to. It just might not be a very good planning tool for you now because every state has their own laws. And in Washington, if you were to move here, we would probably restate the trust and say it's under Washington laws, but it's hard to say. So really good point though. Whenever you move from one state to another, see an attorney in that new state of residence because there's a very good chance that they're going to recommend changes to your estate plan to make it more appropriate. How can I make the successor trustee job as easy as possible? That's a really good question. A well-written trust helps. A well-documented trust, by that I mean the person who's going to be the successor, the next trustee, has really good written guidelines. Here are all the assets in the trust, and here is what this trust is being used for. And here's the name of my attorney that drafted the trust that you should consult with so that you can understand what your fiduciary duties are and what the laws are with respect to investing the trust, etc. That's something that people often don't want to do is go see the lawyer, but seeing the lawyer and paying the legal fees can make things much, much easier. We did talk about a little bit about lifetime gifting. I really want to make sure that I take time to discuss this with you. Sometimes people have accumulated money throughout their lifetime and it surprises them. They'd never had a high-paying job, but they were a saver and they saved their money and they saved their money. And now they're a single person, they live in the state of Washington, and now they have $3 million and they're 90 years old. When we meet with that person, we talk with them and explain to them that if you are interested in charitable gifting, then $1 million of your estate might be directed to charities so that you avoid the state of Washington imposing an estate tax. Because remember, Washington only allows $2.193 million to pass to any person without a tax, an estate tax being imposed. So if that person has $3.193 million, that's $1 million too much, and about $100,000 in taxes is going to be paid on that person's death, unless that extra million went to charity. What can they do? They're still alive. They don't want to pay an unnecessary tax of $100,000. What can they do? They can give away their assets. They don't have to give it to a trust. They could, but let's say they've got 2 kids. They can give $500,000 to those 2 children, $500,000 each. 500 times 2 is $1 million. They give their beneficiaries that money now during their lifetime. No taxes are paid by anyone. And upon their death, now their estate is within Washington's limit of $2.193 million. And that money then goes to the 2 kids, again, with no taxes. So whenever you get above the $2.193 million threshold, especially if you're a single person, talk to your estate planning and elder law attorney, because the advice we give may be give that money away now. Don't pay estate taxes on your death. If you want the money to go to people, an easy solution is to give away $1 million. And now remember, we talked about the fact that Washington has no gift tax. You can give away money in Washington. You can give $12.92 million away with no taxes being imposed. That is in addition to the $17,000 you can give to unlimited number of people every year. So it's a very simple estate planning technique to avoid estate tax is to give money away to the people you want to receive it during your lifetime. If you're giving away money during your lifetime, money is okay to give away. Be careful about giving away an asset that has appreciated. By that, I mean an asset that when you bought it, you didn't buy it for much, and now it's worth a whole lot of money. Why is that? Because when people inherit from you, the tax code says that the basis of that asset is adjusted to fair market value. That is a really important benefit of the tax code and of inheriting. Let me give you a really quick example. Let's say you are really smart, and in 1986 you bought $1,000 worth of Microsoft stock. As of the end of last year, 2022, that $1,000 was worth more than $3 million. Don't give away that stock. Give away other assets, because if you give that stock away, it is given away with what's called the carryover basis. And whomever you give it to, if they sell it, they now have a capital gain of $2.99 million. They're going to have to pay about $580,000 in capital gains tax. Whereas if they inherited that stock from you and they sell it, they pay zero. I mean, imagine, it's almost a $600,000 capital gains tax that can be avoided by giving away different assets, not the stock or assets that highly appreciate. All right, there's a whole bunch of stuff that I wanted to cover, but I think I covered the majority of really important techniques and secrets that I wanted to share with you. Thank you for sticking with me. If you have any questions, feel free to reach out to us at ELG Estate Planning. Our phone number here is 509-468-0551. We will be sending you information for those of you that joined us via Zoom, or which will be this recording, and also a guide for estate planning. I hope that you got some really good information from this, from attending today. please feel free to share it with people that you think might also benefit from it. And again, if you have any questions, if we can help you in any way, don't hesitate to reach out to us. Thanks again.